Welcome to the second part of the judicial branch. As we talk about judicial review, recall earlier in the course we discussed about the Federalist Papers and Alexander Hamilton. The Federalists viewed the judicial branch as the least dangerous branch of the government for two main reasons. It had neither the power of the purse, the ability to raise funds, nor the power of the sword, the ability to defend itself, or commonly referred to as the military. Please make sure you review the video, Marbury versus Madison. As you know, Marbury versus Madison is where Chief Justice John Marshall first utilized the doctrine of judicial review. Next, we look at strict constructionism versus judicial interpretivism. Strict construction of the law is where a judge looks at the text of the law in a very formalistic way. He determines its meaning based on the way the law is written. He does not look any further. With judicial interpretivism, the judge interprets the law in light of social changes and society. She considers the Constitution or the law as a living document subject to modification determining on society. Next, we look at jurisdiction. Courts with original jurisdiction are your trial courts. In the state system, they're known as state trial courts, or in Augusta, the Superior Court. In the federal system, the U.S. District Court is the court with original jurisdiction and is the trial court. Courts with appellate jurisdiction, the U.S. Court of Appeals. As we know, there are 12 circuits of appellate courts in the U.S. system, called the circuit courts. In the state system, there are often intermediate appellate courts, such as in Georgia, there is the Georgia Court of Appeals and the Georgia Supreme Court. Then there are those courts that have both original and appellate jurisdiction. Although not exercised very often, the U.S. Supreme Court has both original and appellate jurisdiction. So to review, the federal courts are composed of the district courts. There's 94 district courts. That's the trial court. The Circuit Court of Appeals, there's 12 Circuit Court of Appeals. We are located in the 11th Circuit Court of Appeals. They hear appeals from district courts within their circuit area. Then there's the U.S. Supreme Court, the High Court. Let's look for a moment at federal judges. Federal judges are appointed by the President, but they must be approved and confirmed by the Senate. They are appointed for life. Federal judges can only be removed through the impeachment process by the House of Representatives and then conviction by the Senate, similar to impeachment of the President. It is thought that the appointment process will insulate judges from the temporary passions of the public and insulate them from political aspirations and political concerns. Senatorial courtesy is often invoked for lower-level federal courts. If the President wants to appoint a judge at the district court level, he will confirm with the high-ranking senator from that state that the appointment is acceptable. The next slide shows the percentage of judges confirmed by different presidents on an annual basis. For example, you will see Carter average appointing 66 judges that were confirmed